At this time, I'd like to call to order the public hearing scheduled for Tuesday, November 24th. Shannon, would you call the roll?
Mr. Yates?
Here.
Mr. Fury?
Here.
Mrs. Stauffer?
Here.
Mr. Roden? Mr. Ceresi? Mr. Scafidi?
Here.
Mr. McDermott?
Okay, can you call the roll for public participation?
I think Lauren is.
Do we have to be sworn in, Dave, or anything?
No. Do you need the microphone?
No, I get it.
Oh, okay.
First is Lauren Sunstock.
Call. Procedures, man.
Yes, Lauren Singstock from 2704 Arbor Glen Drive. I'm here this evening to address the issues that are coming up here on the C5 mixed-use district. Seems once again the city of Twinsburg elected officials are attempting to continue confusing, misleading, and convoluting our Title III district regulations contained in Part 11 of our Planning and Zoning Code. How is this once again being perpetrated on the citizens? And Shannon, I'm giving you this copy so you can include it in the public record so that it doesn't get lost or anything. If we look at our zoning regulations and planning regulations, they're comprised of 6 titles. There's Title I, the general provisions, Title III, district regulation, Title V, special use regulations, Title VII, performance standards, Title IX, standards for land development, and Title XI, administration and enforcement. Title III includes sections 1137 to 1161, and those revolve around our zoning district regulations, which pertain to Charter Article 7A, specifically Section 7A01, regarding changes to zoning districts and classifications, which multiple court cases and court decisions have confirmed. It is here that the confusion is being perpetrated, again, by Ordinance 132-2015, in my opinion. Since it is not and does not pertain to district regulations requiring a vote of the people, it should therefore be corrected by being assigned within the proper title of our zoning code and regulations, which I would think would be like Title VII, Title IX area. The city has lost multiple times in court by attempting to circumvent and deny voters our lawful rights we have reserved under Charter 7A01. Specifically, over a year ago in the city hall out here, Mrs. Gadosh, Mr. Maestros, and myself discussed this very issue. And it was agreed at that time that Title III, containing sections 1137 through 1161, where I recall Mr. Maestros agreed with us saying Title III had some real messes in it. Now the city is attempting to continue the mess by purposely continuing with its convoluted and illogical placement of sections of our zoning law into Title III that have no business being there. Since the mayor, law director, and economic development director seem intent on continuing this mess with improper placement of subdivision and or building material issues into Title III, I recommend that City Council bring an outside independent planning and zoning firm that specializes in planning and zoning code to look at the design layout of our code, put it back into somewhat legal compliance and get the sections where they need to be, and review the proper necessary changes or amendments to put an end to this mess and provide clear and concisely what Title III should be, so in the future the citizens will clearly and concisely know what we vote on and what we don't. One of the other issues I want to address that pertains to this is our zoning map. It's clear that the city has issues surrounding the validity of its current zoning map, and that is due to negligence, in my opinion, and proper changes to the zoning code map, or zoning map, and more specifically to the following. More than 60 parcels of land appear on the zoning map as C5 mixed use, which appears to have not had a public hearing or a vote of the people. How this happened rests with the mayor, law director, and economic development director, who must provide the following documents for clarification. And these are the questions I have, and I'd also like them to be considered public records requests. First, I want copies of the public hearing notices and the public hearing minutes wherein these changes to these zoning over 60 parcels of land were changed to C5. Where in Ordinance 69-2008 is any authorization provided for changing the zoning map. Copy of the resolutions and election ballots with election results therein to prove that the people voted in accordance with the charter for these map changes. Copy of the official certified zoning map showing what these parcels were zoned prior to 2007 and exactly how they are changed to C5 mixed use. Table 1 of our zoning map changes have no indications of any C5 mixed-use zoning map changes that were done in 2007 to 2008. There's no time in a public hearing. Except for in 2007 to 2008, except Ordinance 45-2007 dealing with 5.8092 acres on Darrow Road from PF to I-3, and Ordinance 141-2008 for certain property located at the northeast corner of Darrow and Old Mills Road owned by the Concord Mill, Inc. from I-2 to C2. Therefore, either no C5 mixed-use changes were done lawfully, or someone needs to address why it was not properly recorded in the index to the map. Until the matter of how and if these properties were properly and legally zoned or changed to C5 mixed use, this council would be well advised to not further perpetrate the potential fraud upon the citizens of Twinsburg. Please do not mistake C5 district regulations, which appear to have been adopted by a vote of the people, not a problem there, but the zoning map changes until proven that they were adopted with public hearings and a vote of the people. If no public hearing, ballot issues, and valid zoning map documents can be produced to confirm the validity of the zoning map changes to the over 60 parcels of land changed to C5 mixed use during the years 2007 to 2008, then the city has perpetrated upon the citizens of Twinsburg the most egregious fraud I have ever heard of regarding land use and zoning codes in my entire life. In summary, these are extremely serious issues the city must contend with, and it is imperative that they be done in a lawful procedure. This mess must be addressed. City Council has a responsibility to make sure that it is. Therefore, it's incumbent upon council to bring in outside independent code professionals, people that deal with zoning planning codes, and don't just, again, use Mr. French because he's a cheap source of somebody to do it. You need an outside independent person to look at this code to truly fix this mess up. It is not something that's overwhelming, but if it continues, it's kind of crazy in my opinion. I'm reminded of the old adage that when you have dug yourself in a hole, the best advice is to stop digging. And my advice to council is to get this straightened out and stop digging this hole deeper. Thank you.
Thank you. Is there anybody else for public participation?
There is none.
Okay. The public hearing tonight was really on the construction materials that would be used, and so let's deal with those issues tonight, because the others would be not relative to that specific question.
Is that a question to me, Mr.
No, that's a
Perry?
statement that I'm giving you. I said that we would deal with your questions about where this would be, whether this would, where in the code this would be put.
Oh,
So,
okay.
All right, and that, talking about the issues with 2008, we can deal those aren't really relative to this issue.
They are relevant to the whole concept of the C5 mixed use of the zoning map. That's what I'm talking about.
Okay, but we're talking tonight.
Your regulations, if you have not legally adopted the C5 mixed-use areas in the zoning map, lawfully done that, you're talking about changing materials, which shouldn't be up in Title III, but should be down in another title. That's a semantics issue, but let me explain. You're saying it's not pertinent, and I disagree.
Well,
And the reason I disagree is this. when you have all those parcels, where are you going to apply these regulations to before you have straightened out the issue of the zoning map? There's only about 6 parcels of land over on, I think it's, whatever that road is, over by McDonald's, Ravenna, or not Ravenna, what is 82? What do we call that?
Aurora, East
Aurora
Aurora.
Road, East Aurora Road. There's a strip of properties in there that were zoned C5 back in 1989. If those are the only parcels that are lawfully zoned C5, as what I can find in public records, because I brought this question up before, and it has not been addressed by council, and it needs to be addressed by council. That's the
Well, I
only
had a
place
call from Mrs.
lawfully
Gadosh for
you
the
can
last
put those
few-
materials to use.
Well, I had a
So
call.
you guys are going to do whatever you want. I just want the public to have a public record that I don't believe that was done right.
Okay, thank you. Mr. Maestros,
Yes.
we've made some charter changes in conjunction with input from Mrs. Gadosh on what items need to be voted on. Could you go over the list of items that we need to vote on regarding changes to this building code, or address Mr. Or Lauren's issues with this, please?
Certainly.
Thank you.
As council's aware, we've had a number of items of litigation over the last several years regarding Title 7 or 7A01 of our code, and essentially the issue is what does or does not have to go on the ballot when it's been presented and approved by Planning Commission and recommended to council. And that has been the bone of contention for quite some time. So last year, Mrs. Gadosh, her attorney, and I sat down in an attempt to characterize the items that should go, are required to go on the ballot, and those that are not. And the problem that we had is that originally we went down this path, similar to what Mr. Sangstock is saying, well, everything in Title III should have to go on. And then as we worked down that path, we found, well, that's not entirely accurate, because there are sections of Title III that clearly do not have to, that do not relate to density and height and business and use and prohibited uses and all the restrictions that were contemplated in 7A01. So instead of going down that path at the request of Warner Mendenhall, Mrs. Gadosh's attorney, we sat down and put together a list. And we came up with 8 items that we felt were exhaustive of all the issues that had to go on the ballot. And
Are
we-
those in 7A01?
They're in 7A01, and that is the 7A01 that was presented and passed last spring by the electorate. Now, if I could, those 8 items are zoning district boundary changes, or changes in the use of either prohibited or permitted in those zoning districts. Any restrictions related to height, density, percentage of lot occupancy, building setback lines, area dimensions of yards, and open space requirements. Those are the 8 items that both parties to the pending lawsuit at the time determined anything that affects those would have to go on the ballot. And the problem that we got into is if you just said everything in Title III has to go on the ballot, what we noticed where there were items in Title III, such as what's before you tonight, 114820, such as color renderings, what has to be submitted to the Planning Commission, the Building Department. Color renderings of all building elevations, color photographs of similarly constructed buildings. If, for example, council or the Planning Commission or the Building Department wanted to change that and have it say, we accept email versions of this, that's in Title III, that would have to go on the ballot. That simple change. So we decided, well, that's certainly not what was contemplated, and that's why we came up with that list of 8 areas and anything that falls in within those 8. It also put Planning Commission in a position where they could simply have that list before them and determine that anything that's presented to them, they can see if it falls in that list of 8. And they made the determination that this 114820 amendment does not. So that is why both Planning Commission, Mr. Finch, and myself agree based upon, this is the first, by the way, this is the first amendment to our zoning and building code that falls under this new 7A01 language. So the goal was to simplify this and to make it clear. I think it makes it clear because this does not fall into any of the 8 categories. This is building design standards, period.
Are there any questions on count? Mr. Yates?
Yeah, I guess I'm just trying to, if I think I understand, Mr. Simcock, your position is not necessarily that these building standards need to go on the ballot. Your position is you're trying to adopt standards when the underlying the underlying C5 is in question. Is that,
That's exactly correct. I have no problem with the ordinance as far as whether it should be voted on. It clearly deals with materials. It has no right being voted on. That is not the heart of the question.
And so I think-
The heart
I
of the
think tonight-
question is, if you're going to enact zoning changes, and that map up there, whether it's official or not, says that there's 78 parcels that are zone C5, but only 7 of them have been properly zoned and lawfully zoned C5, then your ordinance, you can pass it as much as you want, my opinion, but it's only going to affect those 9 parcels technically.
I understand that completely, and I'm just
Okay.
trying to clarify that, I guess, for
I
the
just,
record.
I
So
want to make sure that somebody on this council addresses these public documents regarding the C5 zoning in that
I
map
completely understand.
downtown.
So I think, tonight we've got a public hearing on these building standards, which I think we're going to move forward with, but I understand that you want us to
Okay.
take a look at the underlying procedural mechanisms that should have taken place when the C5 was
Right.
shifted on those 60
And
properties.
just for the record, Mr. Maestros, those sections that I bring up were in the court cases, and those are part of the court's decisions way back in 2 or 3 or 4 cases back, where they specifically said that 1137 to 1161 were the section of Title III, and the people reserved unto themselves the right to vote on those sections. If you want to take these sections, then get them into 1162 to 11,000 something, I don't care. But from 1137 to 1161, the court's rulings have said, if you're going to take sections of law and have it so people vote on district regulations in those 8 areas, put it in a spot in the code so that we don't have to worry about it until it says 1137 to 1161. If you want 1162 point something, whatever, for these building material codes, that's where you want to put it, fine. Just don't keep convoluting inner sections of what people vote on versus what they don't. That's the key and issue. It's a lot better in law if you have it systematically indexed the right way. And I'm just telling you, none of the records I can find, and I'm asking for them tonight, in public, for those documents proving that C5 was lawfully done the right way. I believe it was denied public hearing, and I don't think it was actually voted on. I believe there's a huge perception that that happened, but I don't believe it happened because I don't see it in writing. And anything I receive, I don't want to hear about it. I want to see it in black and white. Put those documents together, and then you can present it to me, and I'll be happy to come back and say, guess I was wrong, but somebody did not index it right, and it doesn't appear to have been proper. So that's for what it's worth.
Are there any other comments? Okay, at this time, the public hearing is closed. You want to go right into the caucus?
So